Introduction to Food Safety and the Law. Introduction. This module will teach you where food businesses and preparers stand in relation to UK law and the details of what is expected from you under the legislation which governs food preparation, handling, displaying and serving. You will also gain an understanding of how this legislation is enforced by food safety officers, FSOs, and others, and ultimately what might happen if you fall foul of the law. Topics to be covered in this module. What is food safety? Food handlers and the law. Food business owners and the law. The powers of local authorities. Role of the Environmental Health Officer, EHO. Prosecution. Due diligence. The Food Standard Agency and the Food Hygiene Rating Scheme. What is food safety? Most people love to eat out, and everyone will at some point need to buy and eat food at a commercial or catering premises. However, the preparation and handling of food carry with them a number of hazards. It is a food handler's and food business's legal obligation to protect the public and staff from these hazards, as well as an ethical and moral necessity too. The overriding responsibility of food handlers and preparers and food business staff and managers can be summarized in 3 points. To make sure that all food being handled, prepared, displayed and served is safe to eat. To make sure that all food is protected from potential hazards. To prevent and protect all customers and consumers from harm. Food handlers and the law. Basic hygiene. Food safety begins with cleanliness. In other words, a rigorous attitude towards hygiene. Here are some general tips about what you should do and how you should behave. Maintain your personal hygiene and cleanliness. Maintain the hygiene and cleanliness of your workplace and premises. Routinely wear appropriate protective or clean clothing. Ensure that all food is protected from any contamination at all times. Prepare, display, serve, and store food at legally designated safe temperatures and in scrupulously clean conditions. Report any staff illnesses showing symptoms of food poisoning to your line manager or supervisor. You will find more on this subject later in the course in Module 6, Personal Hygiene. Food business owners and the law. Food safety laws are provided directly by UK law and also from the EU. Both must be strictly adhered to in your business or employment, handling and selling food. These laws are intended to enforce clear standards of food and hygiene on food handlers and managers with regard to 5 aspects of their business. Food safety. Food safety management. Food handling, including appropriate training. Temperature maintenance and control. The workplace and its equipment. The law states that every person involved in food handling, whether they be an employee, supervisor, or manager, must be aware of their legal duties in performing their work. The most important legislation is as follows. 1. The Food Safety Act 1990. 2. The Food and Safety Hygiene Scotland Regulations 2006 and the Food and Safety Hygiene England Regulations, 2016. 3. European Food Regulation, EC, number 852, 2004. 1. The Food Safety Act, 1990. This is the major legislation covering food standards and makes it a criminal offence to knowingly or unknowingly produce food that is dangerous to health, sell substandard quality foodstuffs assessed as those which don't meet standards that might reasonably be expected by a customer, sell food products which do not comply with food safety and hygiene regulations. 2. Food Safety Hygiene Regulations. There are two major sets of legislation in the UK, one for Scotland and the other for the rest of the Union. The Food and Safety Hygiene England Regulations, 2016. The Food and Safety Hygiene Scotland Regulations, 2006. Both of them set out food hygiene regulations for every food business, controlling every level of commercial food production and consumption, from initial production right through to its consumption by the customer. 3. European Food Safety Regulations. The main set of regulations governing food production and consumption across the EU are European Food Regulation EC number 852, 2004. These rules are even wider reaching than the UK's own and concern the handling of food in the following circumstances or contexts. On food production and consumption premises, whether this is a factory, canteen, restaurant, or cafe. Food business registration. Equipment, from cooking to storage, and even down to the maintenance of cutlery. The robust implementation of HACCP or FSMSs. The behaviour and training of the food handlers themselves. The powers of the local authority. The main enforcers of food safety legislation are local authorities who have their powers set out by the law. To enforce regulations and standards in food businesses, local authorities employ two kinds of inspectors: Environmental Health Officers, EHOs, Trading Standards Officers, TSOs. There are also two main organisations in the UK that are responsible for protecting the consumer from food production and consumption hazards. The Food Standards Agency, FSA. The Food Standards Scotland, FSS. The role of the Environmental Health Officer, EHO. The major investigator of a food business's premises and conditions once a complaint has been made or a regular assessment is underway is the Environmental Health Officer, or EHO. In food premises, the main role of the EHO is to investigate the potential or existing health hazards and ensure that they are meeting the legal sanitary standards required by food safety legislation and to make sure that any infractions are eliminated or mitigated for, whichever is most essential. These official operatives have the power to perform any of the following actions, if and how they see fit within the law. Enter any food production or consumption premises at a reasonable time for the purpose of performing food safety inspections. Investigate complaints that they have received about food hygiene and safety. Investigate food poisoning outbreaks and complaints about incidences of food poisoning. Give advice and recommendations on how a food business could improve safety and hygiene. Give guidance and good practice advice to food business managers, employers and employees. The serving of legal notices. One of the most important jobs of EHOs and TSOs is to serve legal notices. There are 3 different forms of these notices: hygiene emergency prohibition, remedial action, hygiene improvement. In addition, EHOs and TSOs have the authority to perform the following actions: take samples or photos of food they consider may be unsafe or unfit for human consumption, confiscate or destroy such foods, recommend that food business companies, managers or staff be prosecuted. The serving of legal notices. Food businesses must cooperate and comply with the law, especially if they receive a legal notice or recommendation from an EHO or TSO. Failure to do so will almost certainly result in a prosecution and conviction for obstruction of the law. You will be committing a criminal offence if you do not act upon or ignore a legal notice or order. Hygiene Emergency Prohibition Notices, HEPNs. If a hygiene emergency prohibition notice is served, it is the law that the business must close immediately. The officer who served the notice must then apply to court for it to be turned into a hygiene emergency prohibition order, HEPO, within 3 days of the legal notice being issued. The business will remain under this order until it can be definitively demonstrated that it no longer poses any threat to public health or safety. Only then will the order be lifted by the local authority. Remedial Action Notices, RANs. Away from England in the UK, Scottish, Welsh or Northern Irish food businesses can be served with a remedial action notice by an EHO or TSO. This means that any use of the food business or its equipment stated in the RAN is prohibited. The RAN can specify a timescale for complete closure or reduction of the business's operations, which can be immediate. The RAN can impose any number of conditions on a food business or production process, or even prohibit such activities. Examples could be that a restaurant will be forced to close for the foreseeable future, or a catering business might be prohibited from providing its services until further notice. Hygiene Improvement Notices, HINs. An officer can serve an HIN to any food business that is found to not comply with its legal food safety obligations. An HIN will usually state the particular reason that the HIN has been issued, improvements that must be made by the food business in order to comply with the HIN, how much time is being allowed for these recommended improvements to be made. This is generally at least 14 days. Food businesses and the law. To avoid falling foul of the law, the owners, directors, and operators of food businesses have a number of additional responsibilities under UK law as follows. All food production and consumption premises must be officially registered with the local authority. At all stages of its preparation and use, all food premises must be properly operated and equipped to prevent contamination of food. Workplace hazards must be assessed, minimized, and eliminated where possible, using appropriately designated and written food safety management procedures and protocols. All food premises must have adequately cleaned, maintained, and constructed facilities for washing and personal comfort and hygiene. Appropriate and thorough training must be given to all employees and staff. Prosecution. What happens if you are prosecuted? Failure to comply with food safety laws and regulations or any notices served by the local authority's officers could result in any or all of the following: prosecution, an unlimited fine, a prison sentence, closure of your business. The length of the prison sentences imposed can vary from a maximum of 6 months if your case is prosecuted in a magistrate's court, up to 2 years if it is held in a Crown court. Either is possible. Due diligence. As a food business owner or manager, you only have one defence under UK law: due diligence. This means that you can prove that you took all reasonable precautions to ensure that the food that is being handled by your business was safe. The only way to adequately prove this is to be able to show that you set up an appropriate system of controls under which any dangers or hazards should have been prevented or minimized. Furthermore, these controls cannot be proved to have been in place without keeping complete and accurate records for inspections and protocols performed, ensuring the source of each food product and tracing their packaging, showing that you rigorously followed the good practice guidelines of the UK food industry. Being able to provide evidence of all of the above is due diligence. Food Standards Agency, FSA, and the Food Hygiene Rating Scheme. The FSA partners up with all the UK local authorities, other than Scotland, to run the Food Hygiene Rating Scheme, FHRS, which governs all food selling and serving businesses, including supermarkets, grocers, shops, and food stalls, restaurants, cafes and takeaways, hotels and pubs. Once one of these businesses has been inspected by the FSA, the Food Safety Officer, FSO, gives it a hygiene rating, which shows how well the business is meeting the standards of food hygiene legislation. The premises should then prominently display an FSO sticker to demonstrate that they have met hygiene standards, a legal requirement in Wales and Northern Ireland, but not in England. Details of the business's compliance are also published online on the FSA and local authority websites. The FSA inspection. On site, that is your premises, the FSOs will assess the following: the structural conditions of the building in which your food business is based and its layout, how clean, well ventilated and lit the premises are, whether the food is handled hygienically at all stages of its production and consumption, including storage, preparation, cooking, cooling, reheating, and display, whether the business has adequate means of making preparers and customers aware of the presence of allergens in each of the foods, how the supervisors, managers, or other relevant staff maintain and record their procedures. The FSA inspection. The highest rating available under the FHRS is 5, and is given if the business's food hygiene and safety are of a sufficiently high standard. In reality, any food handling businesses should be able to achieve this score with ease. If you want to know more about Food Hygiene Rating Scheme, click on the following link. What happens if you get a poor food hygiene rating? This is never a good thing for a food business for a number of reasons, including the fact that your business might have to close forever. You may lose a substantial amount of business. You may lose your reputation in the industry, with the local authority and among members of the public. You might receive a lot of customer complaints, both in person and publicly online. You might be the cause of a food poisoning outbreak. Summary. In this module, we have learned that Your responsibility as a food handler or business is to make sure that your food is safe to eat, protected from hazards, and fit for human consumption. All people involved in food handling must follow the Food Safety Act 1990 and the Food and Safety Hygiene Regulations, as well as the European Food Regulation. The local authority and its Environmental Health Officer, EHO, have the power to inspect your premises and methods when they deem it suitable. You must maintain adequate records of your hygiene and safety procedures to be able to prove due diligence. The maintenance of good food handling standards will result in you being given a good score under the Food Hygiene Rating System and a sticker which should be displayed obviously on your premises.